Hello and welcome to this brief training update on House Bill 14. Today's session is designed as a reminder to ensure we are all using the proper denial process when reviewing and processing permit applications. As part of our responsibility, it is critical that we apply the correct language and follow the required steps outlined by HB 14. This ensures consistency, compliance, and fairness in how we serve our customers. Please pay close attention to the updated guidance provided in this training, as accuracy in permit denials protects both the city and the applicant. Let's review the process together. By the end of this session, you will be able to understand the key information in the newly passed House Bill 14, walk through the processes and procedures for approval, conditional approval, and denial, with a focus on key updates for denial comments, and review the documentation and customer communication requirements. In order to clearly understand House Bill 14, let's review the three major definitions that guide our permitting process. Approved: an application that meets all departmental requirements, codes, and regulations. This means the project is permitted to proceed as planned. Conditionally approved: an administrative decision that allows the project to move forward, but only with specific conditions or requirements. These conditions must be met before full approval can be granted. And denial: an application that has been rejected by the City of Dallas Regulatory Authority because it does not meet the minimum requirements, codes, or regulations. This is the key area we'll be focusing on in today's update. What is HB 14? House Bill 14 is a Texas law designed to streamline the permitting process and ensure timely communication with applicants. Key provisions include final status notification. Applicants must be notified of their permit's final status, approved, conditionally approved, or denied, no later than the 15th day after the prescribed approval date. Third-party review option: if a regulatory authority fails to issue a decision within the required time frame, applicants may engage a licensed third-party reviewer or inspector to assess the application. The findings must be submitted to the regulatory authority within 15 days of completion. Finally, appeal rights: applicants have the right to appeal a denied permit. The appeal must be submitted in writing within 45 days of receiving the denial notice, and should include the denied application, a statement explaining why the denial is believed to be an error, and supporting evidence. The director or their assignee will make a final determination within 60 days. Let's review the reason why we have House Bill 14. House Bill 14 was created to accelerate the development process, improve efficiency in permitting and review, prevent potential backlogs in applications, and strengthen partnerships with builders and stakeholders. Please take a moment and review the slide to see a few more reasons why House Bill 14 was enacted. The approval process: the regulatory authority should approve a plat, plan, or development permit by the 15th day after the date prescribed for approval. If approval is not issued within this time frame, the review may be conducted by a third-party reviewer who is not the applicant. The third-party company must be registered with the City of Dallas. A list of approved third-party reviewers is available on the City of Dallas website. The conditional approval process. Conditional approval: the project is approved under certain conditions. Revisions or additional documentation may be required before final approval. The applicant should receive an intake plan review. Conditional approval comments by the reviewer or intake team member. It is the reviewer's responsibility to ensure that all conditions for full approval are clearly communicated in the comments. Now let's review the updated denial process. You should have received an email from your deputy director with instructions regarding this update. If you have not received it, please contact your deputy director as soon as possible to ensure you have the information needed to comply with the requirements. Denial process update: adherence to requirements. All denial procedures must be strictly followed. When a permit is denied, the applicant shall receive the intake CR plan review denial comments, completed by the reviewer or intake team member. The document must clearly reflect the reviewer's information, the specific reasons for the denial, and mandatory denial comment to include Your application is in denial status until we receive the necessary documents and all comments have been addressed to resume review. This action does not deny your overall application. It only denies your current review until the required items are provided. Please upload the missing documents through the Record Info Attachments tab so we may continue processing your review and provide a written response to all review comments. Let's review. The denial comment is mandatory. Please ensure that you understand this key step to the permitting process. Now, this concludes the update review. Today, we reviewed the key definitions, objectives, and updated processes under House Bill 14, with a focus on denials, conditional approvals, and approvals. Next steps. Ensure you follow the updated procedures and include the required denial comments when applicable. Need help? If you have questions or require additional training on HB 14, please contact the Training and Development Team for guidance and support. Thank you.